responsible. I'd like to introduce Dave Rogers. In addition to working here as an attorney at Davis Malm, he is a state rep. He represents the 24th Middlesex District, which includes Arlington, Belmont, and part of Cambridge, North Cambridge, right? Yeah. Thanks, Dave.
Yeah. I do mostly business law, corporate law, advising companies on a variety of things, and some employment law related to the business transactions, and also serve in the Massachusetts State House. And I've been there 12 years. Fortunately, I have no opponent this cycle, so I guess I'll be there another 2 years, unless blank beats me, and that would be bad.
Dave, we have a rule here, no political discussions in the workplace.
Oh yeah, there you go, there you go. So I'm going to talk to you with updates from the State House. This is legislating that we've been doing recently. And the biggest new law that we passed is the salary transparency law. That has not taken effect yet and won't take effect till next year. But it's good to just be aware of what's coming in the future. And basically any employee, public or private, with 25 or more employees in Massachusetts will have to disclose the pay range of new positions. And it's not just when you post a new job posting, it's also for those in your company who apply for a promotion. It's also just anyone who holds the position, say there's 10 sales reps or whatever the job is, and they say, hey, what's the salary range for my job? You know, and so they could be currently working with you and ask for that information. So it's pretty broad in that respect. And then that one sentence at the bottom is really important. It's illegal to discharge or discriminate against an employee because they exercise their rights under that section. So if they say there are 10 sales reps and one of them asks for the information, you can't say, well, this guy's troublesome and difficult. And the reason I mention that is some of the employment lawyers will tell you in job discrimination cases the employee can't win on the merits of their discrimination claim, but they can win for retaliation or for taking any action because they've exercised their rights. So the other key piece of this is annually on February 1st, employers with 100 or more, so the salary is 25 or more. This is for employers that have 100 or more. You have to disclose your EEO-1 report to the state now. It's already disclosed to the federal government, but now you'll also have to disclose it to state government. And it's anonymized, but it's to give the state a sense of what's happening in the marketplace. The effective date for the salary is not until October of next year. I saw a major law firm in town. I happened to look at they sent out an alert and they said it's July 31st. And that's incorrect. It's not till the end of October of next year. And that was a complicated negotiation between the governor and the legislature. There's a soft, if you will, a soft opening to this new law. That is, for the first 2 years, as long as you correct or remedy any violation, there'll be no penalties, no fines, no ramifications. So I thought that was a sensible, it's a pretty sweeping new law, give employers a full 2 years to kind of implement it, and if they make a mistake or omit certain information, there's a grace period for a full 2 years. Yeah, I think the idea is to get the data and understand how the pay structures are working in various sectors and various SIC classification codes, to get a sense of are there persistent pay gaps. And so, but it's anonymized, as I say. No employer will ever have their information public, and I believe specifically it's the Secretary of State's office, or it could be the Executive Office of Labor and Workforce Development, or both. The next one is the so-called topping off law. We know we have PFML here, Paid Family and Medical Leave. That's a relatively newer law. It's gotten a lot of publicity around the country. Many other states have it. I think when Tim Walz was selected to be the Democratic nominee, there was publicity about how Minnesota has this law. So But what this will allow to do is the pay replacement currently under PFML is not your full wage replacement. And this allows employers, if they want to allow workers to use accrued benefits like earned sick time, vacation, to top off their PFML. It cannot exceed their IAWW, their individual average weekly wage. And the employer will be responsible for monitoring that compliance with that prong of the law. And the theory behind it is to create a competitive advantage for particularly our tech sector, but many sectors competing with other employers around the country. It's a way to offer a benefit to your employees. And so there was a big debate about when to make it effective. November of last year. I think some of you already are calling in with questions about how it works, and obviously pick up the phone or shoot us an email and get in touch and if you have questions about how to implement it. The next thing that's new is part of a big comprehensive tax package we did recently. I don't know if any of you use registered apprentices, but we expanded that program to more types of jobs, particularly in the healthcare sector, high in demand professions and jobs where the state frankly is having worker shortages. So the theory is to offer the incentive to boost employment in those areas. And you employers who use this are eligible up to $100,000 of credit each calendar year. So if you do happen to use that program, let us know. We can give you specific details as to which jobs are covered. And this is a lot of complicated discussion of who qualifies, but the expansion includes certain life sciences, lab workers, healthcare technologists, and a variety of others. But if you use the program, get in touch and we can let you know if the particular employee is covered. The final thing I'll talk about, as you may have heard, there's an election this November. When you go to vote on all the other issues and all the other candidates, there are ballot questions. The one ballot question I want to talk to you about is the Uber Lyft transportation network driver ballot question and whether they can unionize or not. Many of you may have seen the Attorney General. Well, the Attorney General is now the governor. Maura Healey sued these companies, claiming they had misclassified these drivers. You just heard from Tamsin about misclassification. If nothing else, the takeaway is how dramatic the ramifications can be for misclassifying your employees. And you recall the example Tamsin gave that, is this outside the normal scope of what your company does? Well, saying that your transportation driver is outside the scope of what Uber and Lyft does presented a problem for these companies. But there was a settlement. And the settlement guaranteed these workers certain rights. I think $32.50 an hour is a base minimum wage, and a whole variety of other rights that the current Attorney General, Andrea Campbell, entered into the settlement. Now the question will be for all of us to decide as voters in Massachusetts, should they be able to unionize? Because they are still independent contractors, so typically they wouldn't have this right. And the question is, should they? But again, the big takeaway, I think, is to reinforce what Tamsin was saying about misclassification and how dramatic the impact can be when that happens.